Thank you, Madam President. May I ask how much time I have to wrap up?
You have 30 minutes.
Thank you so much. Madam President, I wish to express my profound gratitude to all honourable senators for excellent contributions today. I pause to congratulate my colleague, my fellow San Fernando West citizen and friend, Taylor Joelle D'Souza, on her maiden contribution. It's very good to have her in the chamber with us today. Congratulations, Honourable Senator. Madam President, I have to confess that I thoroughly enjoy debates of the type that we're engaging in today, because we've had a serious opportunity to consider in a very deep way issues of law and justice. After all, that's what we're here thinking about. I'm always interested in what my colleagues have to say, and I have to say that I never take offense to positions of law which are not necessarily in line with the one that I am an advocate of. I always stop to listen to contrary points of view. And therefore, I must note in particular measure the contributions coming from Senator Mark and from Senator Vera. First of all, let me start by saying that some honourable senators had asked for certain statistics, and I can say from the disaggregation of statistics that approximately 403 persons find themselves as multiple accused in roughly 7,163 matters per year. So it's not an insignificant sum. Secondly, there was a submission made that this is expedience over justice. And I'd like to say that perhaps enveloped in that submission is the fear, Senator Vera put it quite plainly, that justice can be thrown away in the movement towards ensuring efficiency. And Senator Vera caught very plainly what I had said, which is aggressive case management. I'd like to remind that the structure that we're currently sitting in is aggressive case management in a very different setting. We're now case managing with criminal proceedings rules. We're case managing with maximum sentence indicators. We're case managing in a docket system. Practitioners would be aware that the Honourable Chief Justice has issued directions up to today, indicating that we are moving away from cause lists, i.e. where your matter appears on a list and you go in and you talk once in a while, into docket management, where the cases are now being, if you start even at the Court of Appeal level, panels of judges sit in docket management, so that be it a magistrate or district judge, a high court judge, a master, or a Court of Appeal judge, they now sit judge wedded to matter. In other words, then your matters are now put into the docket of a judge, and it doesn't go into the vagaries of judge to judge. As exciting as the chamber court used to be in the civil arena, where you really learned so much in practice, docket management has taken us to a very different system of administration. So I want to caution that the expedience is not an irritated judicial officer dealing with a list that the judicial officer is not deeply aware of, because the manner of administering justice is now under a docket management system with criminal proceedings rules. Now, Senator Vera raised the point of constitutionality. And I think the Honourable Senator was right to raise the issue of constitutionality, but permit me the opportunity to address it and to perhaps give a reflection which may satisfy Honourable Senators. We always look at constitutionality. The first thing that hit me when I was looking to these amendments was that this is saved law. It's 1918, it's 1936. It was certainly done before a Republican constitution. And even though on the face of it, it appears to be simple majority law as passed, it is certainly saved law, and we didn't have the reflections and constitutional positions that we do now. So therefore, the simple argument that this is a simple act of Parliament passed as such, and therefore does not require a simple amendment, is not one that you can immediately throw out. We must therefore go to the Constitution. We look at the preamble. We look at Section 4 of the Constitution, the guarantee of a fair process, the guarantee of equality of treatment. We must go to Section 5, as Senator Vera took us, Section 5 to F and H, and we must understand what the overriding constitutional objective is, and that is to then be looked at in the context of what the highest court of our jurisdiction has said in relation to what is a fair trial. And that is to be found very importantly in the case coming out of Antigua and Barbuda, and that's the case of Hilroy-Humphrey. The Hilroy-Humphrey case dealt with the abolition of preliminary inquiries. And the argument mounted in the Hilroy-Humphrey case was that a preliminary inquiry is an aspect of a trial which, because it allowed in the Antigua context for cross-examination and other interventions into the law at preliminary inquiry stage, the argument came that preliminary inquiries touch and concern fair trial and therefore cannot be abolished. And if you transpose this argument, the question before us as a parliament today is the removal of consent for joinder something which affects a fair trial? Because the only aspect of constitutionality that we need to look at that touches and concerns sections 5.2h and 5.2f is the issue of fair trial. And because Senator Heath was so clinical in his diving, he has saved me from some of the extrapolation of the argument put by him, which I adopt. I adopt Senator Heath's argument because, number one, we're dealing with joinder of two or more complaints or two or more parties, but it is materially based upon the fact that the matters are founded on the same facts. And that is very different from the language which we used in the original 64.2. The original 64.2 says, and such complaints refer to the same matter. It does not say, as we put now, that they're founded on the same facts. So there is a satisfaction of Senator Vera's concern, because Senator Vera's concern was not on the basis that they're on the same facts. It was on the basis that there were similar facts. 64.2, as it's originally cast, the one which we seek to amend, says, and such complaints refer to the same matter. Now, a same matter does not mean same facts. The reason why we went with the language same facts is because in Barbados and Guyana, that is the language that has received judicial interpretation. We've had the benefit of the law being dealt with on same facts. And secondly, we've had the benefit of the law being considered in the context of constitutionality. Guyana and Barbados both have the CCJ as their final court of appeal, but they were at the Privy Council, and the Hilroy-Humphrey case certainly does have grounding on the argument that the fair trial provisions are preserved. Senator Heath held on to the word may, and the word may is intended to preserve the constitutionality of the separation of powers. Because in section 99 of the Constitution, the supreme law, the judiciary cannot have its discretion curtailed by the legislature. And therefore, we don't say shall, we say may, and we preserve that it is for the court to be satisfied. If the court thinks fit, is what we say in the new section 64.2 as proposed, that the matters be heard and determined together unless the court determines that separate proceedings are required in the interest of justice. Now, what came about in the Clayton and Norfolk case is very materially important to us. And if we look to the jurisprudence, very ably set out in God Rest Her Soul, the book by Dana Sita-Hall, that is Criminal Practice and Procedure, the 4th edition. But if we look to Clayton and the Chief Constable of Norfolk, it was very instructive to note at page 989 of that judgment. First of all, the court at letter G looked to the historical antecedents of where the requirement for consent had been determined in the common law to be a condition precedent, because there was no statutory provision in the United Kingdom, but the law had grown up and had been interpreted such that consent was a condition precedent, like our statutory section 64(2) requires. And they say here at letter G, and I'm quoting from the judgment, second, unless restricted by statute, magistrates' courts guided, where necessary by higher courts, are entitled to develop their own practice and procedure and adopt it to the contemporary needs. The court went on to say, practice and procedure must never be allowed to become inflexible. They are the servants and not the masters of the judicial process. I doubt whether any consistent practice in the last century can be deduced from these cases, for some undoubtedly demonstrate a clear refusal on the part of some courts to interfere where two or more informations or indeed offenders have plainly been tried together. What the court went on to say in the Clayton case was also extremely useful, and if we look to page 992, the statement from the court is, and if you'd permit me to quote at letter A, today I see no compelling reason why your lordship should not say that the practice in magistrates' courts in these matters should henceforth be analogous to the practice prescribed in the Asim case in relation to trials on indictment. Stick a pin, trials on indictment, where a defendant is charged on several informations and the facts are connected, for example, motoring offenses or several charges of shoplifting, I can see no reason why those information should not, if the justices think fit, be heard together. Similarly, if two or more defendants are charged on separate informations but the facts are connected, I can see no reason why they should not, if the justices think fit, be heard together. I've paused on the word indictment to make my third submission. For us to mandate the requirement of consent in relation to summary joinder is for us to ignore the fact that the indictable processes under which we operate do not require consent. In fact, it is axiomatic that it is the prosecution that decides on the joinder, because the prosecution presents the information. And therefore, for us to take Senator Mark's recommendation that we condescend to granular particulars and offer choice and then give reasons why the joinder is not being facilitated, etc., is to take us away from the manner in which we have treated with indictable matters and which stand on the law books today. What the Clayton judgment also says, coming from the English jurisprudence, is that the inconsistencies of asking for consent grew up in the practice in the 18th and 19th century English courts. And it was then that the courts went on to say that the law of practice and procedure must not be maintained in a status quo formula or in a static position. But Madam President, permit me to say that there is nothing, and Senator Heath touched upon it as well, there is nothing to stop the submissions being made as to why a joinder ought not to happen. And it is there that the formula, the interest of justice, comes alive. Now, Senator Mark has asked for indicators into the legislation as to what the interest of justice means. And I would just like to say, as Senator Sagram Singh said so capably and so comprehensively, the concept and the phrase interest of justice is part of the body of laws of the Republic of Trinidad and Tobago in umpteen laws, be it the Supreme Court of Judicature Act, be it in the plea bargaining and plea discussion legislation. It is a feature of law that is left to judicial discretion. Found in the Supreme Court of Judicature Act, every time we settle pleadings, we say such other relief as the court may in the interest of justice deliver. And that is a pleaded case. Fortunately for us, there are umpteen precedents. There's stare decisis. We have formula as to what interest of justice means in relation to joinder. Fortunately, as Senator Sagram Singh again so capably put out, we have the benefit of all of the factors being considered in the round as it relates to abuse of process, as to judicial review, as to appellate function. There is again due process. And that takes me back to Hilroy Humphrey and right to fair trial. Because what we are mandated to consider in the new 64-2 joinder, we're mandated to preserve a fair trial. Number one, we have a judge, in this case, the district judge. Number two, we have the judge bound by statute to act in the interest of justice, coincidental with our indictable procedures and with our common law precedents. Number three, in the interest of justice is subject to appeal because, of course, there is an appellate function based upon magisterial decision. And, of course, there is a right of judicial review in relation to judgments coming out of the magistracy. In fact, there is a case now under appeal. I won't talk about it in a way such as to prejudice the case, but recently we're all aware that the DPP was the subject of a successful judicial review matter, which is now on appeal. So the law is broadening. If you wanted to add to that, take Section 14 of the Constitution as well. So, Madam President, it's material to note that the discretion to try charges separately is circumscribed by known markers to us. That is judicial discretion, that the judge may, that is open to submissions at the bar as to whether there should in fact be joinder or not. The judge is not bound in the consequences to say yes or no. It is in the interest of justice. I also want to lay on record for consideration. What time is full time, Madam President?
You finish at 5:57.
Thank you so much. I'd also like to lay on the record, I want to go back to the Dindial case, and that is the judgment of Mr. Justice of Appeal Prakash Musai. And I'd like to go to paragraph 20 of that case at page 7, and permit me, Madam President, to read this into the record. The judge says, pursuant to section 64(2), where such complaints refer to the same matter, the magistrate may, in the exercise of his discretion, hear and determine them at one and the same time. Thus, statute confers a discretion on the magistrate as to joinder. I'd remind that is exactly being preserved. The discretion is not unfettered and must be exercised judicially. That applies to the amendment that we're proposing to section 64(2). There is no reason why, as a matter of principle, the test postulated by the House of Lords in the leading case of Clayton, and that's the one I referred to earlier, a decision based on the joinder of informations in the magistrate's court, should not be apposite for the exercise of discretion under our statute. We are in those four corners in the amendments that we're proposing here. Accordingly, this is important, the court should ask itself whether it would be fair and just to the defendant or defendants to allow a joint trial. And again, that is being preserved in the amendments that we propose to section 64(2). Permit me, Madam President, to also read from paragraph 22 of that judgment. And I quote, as indicated earlier, section 64(2) was first enacted in 1936 At the time of enactment, as Clayton recognizes, it was difficult to deduce any consistent practice in the magistrates' court from the 19th century and early 20th century authorities with respect to the trial of more than one information at the same time, or the trial of more than one offender charged on separate informations at the same time, however closely related the facts may have been. However, by 1947, Lord Roskill remarked that a rule of practice and procedure had evolved, which made it irregular for any magistrate's court to try more than one information at the same time in the absence of consent. Stick a pin. That is the common law equivalent of our statutory provision in section 64.2 as it currently stands. I return to the quotation. Nonetheless, the House of Lords in Clayton clarified the law, holding that where a defendant is charged on two or more informations, or where two or more defendants are charged on separate occasions, in either case the facts are sufficiently connected to justify a joint trial, justices may try the informations together, if it is fair to do so, even if the consent of the defendant or defendants to that course being taken is not forthcoming. Now, if I take Senator Vera's submission that the consent is the bulwark to fair process and to preservation of rights, clearly judicial determination has a different point of view. I take the submission for the very real point that, and I've said it before myself in relation to bail considerations, that we're sometimes trying to protect against bad judicial decisions. If we are frank on the record and we look to the comparators in the law of bail, and I have said it before and I've quoted from the House of Lords in England on bad bail decisions, perhaps it is that Senator Vera is saying what we all know, that we're trying to protect against bad magisterial decisions. But I would respectfully say that we have to allow the law to grow up and to not be cast into static position. Because if we accept Dindial, the way Mr. Justice of Appeal Musai has pleaded the ratio of that case, then one could argue that we don't even need to amend the law because consent is not necessarily a full condition. But Mr. Justice of Appeal Musai did recognize that formalities and statutory formalities are formalities, and therefore you can have a miscarriage of justice if you don't carry it out. But that's where Senator Rambarat's submission is so poignant. Because if we look to section 64.1 of the Summary Courts Act, then we have an inconsistency to treat with, where we're trying to understand cross complaints being done without consent. Because if you take this similar fact matter, if you take a cross complaint, it's two different parties, it's one against the other, but the other in reverse to the other. It's an approbation and reprobation. It's people just not agreeing. The cross complaint without consent therefore flies in the face of consent in 64.2. And therefore my submission is that 64.2 is an anomaly that needs to be corrected. And yes, Senator Dial Singh spotted it for what it is. It was mental and jurisprudential gymnastics on the part of Mr. Justice of Appeal Musai in having to bend over backwards to make sure that the law applied. But if you look to the case of Quash, you may not be that lucky as you were in Dindial. In Dindial, the court was able to infer that the formalities of information and consent were dealt with because they were legally represented, and therefore having asked the lawyer the question, the argument was met. Even though Mr. Jagdev Singh, who argued for the appellant in that case, said, well, look, yes, the lawyer said yes, but he didn't ask the person directly. That's the facts of Dindial. So I respectfully submit that our interest of justice argument, our preservation of the fact that the judge has the discretion, the fact that the concept of in the interest of justice is well known to the jurisprudence of Trinidad and Tobago, the fact that we are now treating with criminal proceedings rules, the fact that we are treating with docket management and not just case management on an ad hoc basis. 5 minutes?
Attorney General, you have 5 minutes.
Thank you. The fact that we are treating with our administration of justice in a very different way, particularly now where the rapidity of transcription is now here. Folks, honorable senators, in 2015, we had 10,000 transcriptions in arrears. Today we have none. How did that happen? We entered into a system of voice transcription. The Chief Justice said, if Siri could do it, so can the judiciary. And they started mass transcription. In other words, then, they were dictating speech. So we are now in a position where we have 3 magisterial districts, not 14. Where we have registrars of court, not clerks of the peace. Where we have judicial docket management. Where we have a public defenders division. I will warn Senator D'Souza, the last senator to sit temporarily on the opposition bench was Miss Haseen Sheikh, a very bright young lady who then became the chief public defender because I'm the AG of the Republic of Trinidad and Tobago. And it mattered not to this government that Miss Sheikh sat opposite me. She was the best person for the job and has done an outstanding job for the Public Defenders Department. So I would say to Senator D'Souza, watch out, you may soon be on the other side. The point that I'm making is that the judicial system is very much in a different place. It's not perfect. We are working on a prosecutorial reform at the AG's office. We're in discussions with the Commissioner of Police and the DPP's office because they conduct at the TTPSN 95% of the prosecutions and the DPP supervises 5%. How well is the system going to function? Because now we have public defenders. Madam President, of the 1,200 and odd 5 people in remand for murder, the Public Defenders Division has already interviewed over 788 of them, with hundreds of requests for plea bargaining, with hundreds of requests for different versions of charges to come in. That is no small feat, Madam President. So the system and administration of justice is there. And I would say to my learned colleague, whom I have the utmost respect and regard for, Senator Vera, if we're treating with this to treat with bad magisterial decisions, which I agree with can happen because we are infallible, we are not infallible as human beings and magistrates are certainly human, I would just say that the system is significantly different and that the mere fact that we have transcriptions in no backlog, we have the right of appeal because these are summary trials. Remember, we're not dealing with preliminary inquiries or going to the assizes. We're dealing with magisterial appeals, and therefore the process is much shorter. So, Madam President, I thank honourable senators for very fulsome and intellectual and rewarding contributions today. My humble submission is that the law is constitutional. It does not infringe upon constitutionally entrenched rights. I believe that there's ample precedent in our own lex, in our own body of laws, where the indictable process is without consent. I believe that the jurisdictions of Barbados and Guyana, in particular in the Commonwealth perspective, help us in the CARICOM context because we are in pari materia with them. I believe that the common law set out in Clayton and Chief Constable of Norfolk is excellent precedent for us. And I accept that we are at a system where 500 people's matters, 500 people in 7,000 matters is an important statistical output for us because, Madam President, as I end, people are crying out for justice. And the one part that we can deliver as senators is to ensure we do our end of the equation to enable them with legislative techniques that can help them to feel and smell justice in reality. Because contrary to Senator Mark's submission that it is only certain people, everybody who is in the court needs to know that justice is not only done, but is seen to be done. I thank you, Madam President, and I beg to move.